realestate.com. It's that time again. It's that time again. Laura Dwyer-Schlecki, Mark Meyer, special guest today.
We have Ron Ellison with us. Oh, I have two. We're trying to figure out who's going to use which mic, and if you want to see that, you can watch it on the World Wide Web.
Well, that'll be awkward.
At thinkingrealestate.com. Got to give them more reasons to go to the web.
Yeah.
So we brought Mark. Oh, we have Mark. We brought Ron in to talk about MERS.
This will be exciting.
Well,
this will be exciting.
It is exciting.
Okay.
In order to ask a question, if anybody has any questions about real estate,
They have to email you.
right, which is mark@thinkingrealestate.com, and I do have my trusty computer running. And if you want to text me, this is new.
Oh, wow.
I like texting. I don't do the Twitter, but I like texting.
Okay.
740-2028.
Okay.
Or you can call us at 787-3397.
Can they call you, Laura?
Well, it's like last week. You know, it was really full, and we had a lot of calls last week.
We did.
You can call, but we got a lot of stuff we want to get in there.
Okay.
So, before we start on the MERS thing, though, Ron, you were quoted in the newspaper recently.
No.
In fact, 2 days ago.
Why don't they leave you alone, Ron?
About the new foreclosure legislation, and then also, I don't know if any of you read the blogs below articles, but apparently Bill Jors talked about that on Tuesday.
Mm-hmm.
And his name was mentioned in a blog. So I would like to...
Was it kindly mentioned?
No, not really.
Oh, okay. Well,
But I gotta
we'll leave
say,
it at that, then.
that new redemption thing, reducing it to 3 months from 6 months, I have to agree with Ron that if all the banks did what County National does, I mean, they go above and beyond working with people.
True.
Then the 3 months might be reasonable, but we're not talking about County National banks like County National. We're talking about
the big box banks.
The banks of America.
Right. Well, Laura, the way this started is all the big banks are complaining about the looting and stealing stuff from the foreclosures, whatever. And legislation was introduced to reduce the redemption period from 6 months to 3 months. And this is a result of 2 years ago we came up with something called the 90-day law, that before the lender foreclosed, they had to give you notice that you were in default. They had to offer you counseling,
right,
and try to work things out. And the lenders didn't like that because it extended everything 3 months. So that law is going to sunset. And so this is what they call a compromise. If we gave you the 90 days, let's lop 3 months off the end. And, in my opinion, and it's another story, the 90-day law hasn't done what it was supposed to.
It has not. I mean, I don't know how many people you've talked to, even Mark, I don't know how many you've talked to, that say they've been working with a bank for 2 years and they just got their notice that they're declined from the modification, and they're not just 2 years from fixing that problem. They're also now $27,000 further in debt because they gave them a partial relief of their mortgage payment, and that relief didn't go away. It just kept stockpiling on to the current mortgage payment.
So you're over 2 years in? That would sound like a debacle.
Well,
right, but they've been giving these homeowners hope and promises, and then they don't fulfill them, and now they want to take away 3 months of their ability to rectify the problem.
They being who?
The banks.
The banks.
Why don't the lenders just accelerate their redemption period to 30 days for homes that are vacant?
Mark,
and I recognize that that would be a logistical thing, but that they can solve a lot of that problem by just following the laws that are currently in place.
Well, Mark, that makes too much sense. Nita Delaney asked me, and this was probably 3 weeks ago, I went to Lansing and testified at the House State Banking Committee where this came up. And I sat there for an hour and a half before I testified, and it was apparent to me that the representatives around the table didn't understand the current law, because I said just what Mark said. 10 years ago, we didn't have this looting problem. Again, somebody said to me the other day, well, Bill George disagrees with you. And I said, well, I really don't think so. I agree with what Bill said on his show the other day.
Which was what?
Well, Bill is in favor of shortening it. And I can see that, because if every bank communicated and tried to work with people like County National did, this wouldn't be a problem. The problem is the big box banks that, it takes you 3 weeks to get a payoff. Working on a short sale can take 6 or 7 months. And at the hearing, I said it's a communication problem, and also with the 1 month redemption period, if you vacate or abandon the property, it's there. There's a lot of confusion in Lansing, and there's a lot of confusion in understanding this. So I know where Bill's coming from.
I have not seen one house.
You weren't surprised there was a lot of confusion in Lansing.
That's why I left. Yeah.
I haven't seen one accelerated redemption. Not one.
Mark, I see the 1 month. It's becoming more of the norm, and when it's there. And the problem is the lender who foreclosed, there's a breakdown in communication to tell them that it's vacant. And then again, we're in the middle of the winter, and they don't get it winterized. I mean, again, we don't need more legislation. We need enforcement of what's there. But it's pretty frustrating. So.
And I have seen banks try to accelerate, but the sellers that I've been working with have said this home is maintained and they keep the heat on and they've winterized it and stuff. And I think they had to provide proof to the lender.
And then I've got a client who's lived in a house since 1990 that's been trying to do a loan modification for 18 months.
1990?
1990. No. She's been living in the house since 1990.
Oh, okay.
And her lender, Bank of America, has declined her loan modification because they say she doesn't live there.
Oh.
Right.
Twice.
I'm sure she's registered to vote, and that would kind of help prove it. And she has tax returns.
And the information that they asked her to provide, they said wasn't adequate.
Oh. All right, and the saga goes on. We'll watch this.
So it's messy.
It's gonna get debated quite heavily, I think.
So let me explain what MERS is.
But if it's debated in Lansing, Ron just said they really don't have a clue.
Oh,
You cannot have a battle of wits with unarmed opponents.
Okay,
Anyway,
that sounds like a commentary.
MERS is the Mortgage Electronic Registration Systems Incorporated, and it's a privately held company that operates an electronic registry designed to track services or servicing rights and ownership of mortgage loans in the United States. And it's basically a company that was set up strictly to facilitate the transfer of mortgages and documents
Electronically.
electronically.
Right.
so on April 21st, the Michigan Court of Appeals ruled that MERS was not a party who could initiate foreclosure proceedings under Michigan law. So tell us what that means, Ron.
Oh, confusion again.
Wow.
Well, first of all, MERS was created by the title industry and the lending industry to electronically warehouse loans that were being sold. Okay, that was the intent. And from our standpoint, throughout the years, it's worked great as far as, getting payoffs or whatever. I mean, we go online to the MERS website. With all the foreclosures, and this is not unique to Michigan, I guess that's the thing we need to understand. In Michigan, the title standards say that if you're going to foreclose a mortgage, you have to have an assignment of that mortgage. In other words, let's say Citizens Bank made a mortgage 4 years ago. They assigned it to Bank of America. That assignment has to be of record in the Register of Deeds for Bank of America to foreclose. Well, here's MERS, an electronic clearinghouse, doing foreclosure work under their name, and there is no document in the Register of Deeds here in Jackson that says MERS is the holder of that mortgage. Okay, that's cut and dried. So the appeals court said, you know what? You're right, MERS does not have the standing to foreclose those properties. So we have, I don't know how many foreclosures out there that have been deemed invalid. And so since April 21st, when this ruling came down, there is a lot of confusion in our world. Laura had a closing that we were supposed to have this week where HUD was going to sell this house. MERS foreclosed, went to MERS, and then MERS claimed it over to HUD. That's considered invalid right now. So in a nutshell, that's what's going on right now.
But it says right here on their website, the statement from MERS on the recent Michigan Court of Appeals ruling that title companies should not have any concerns about closing loans with MERS as the mortgagee.
MERS, that's easy to say, but tell them to line up and talk to the title industry, because based on what the Court of Appeals said, and again, this is a decision not for just Michigan. Other state courts have said this. And so a title company is saying, based on this decision, John Doe, who just lost their house, was improperly foreclosed on. And the court clearly said that's invalid. So it's easy for MERS to say that, but we're not into buying lawsuits. And, Laura and I had this discussion, and I have 4 underwriters, and they're all in agreement that, if MERS did that foreclosure today and is trying to sell it through the current lender. Now, there's another dynamic that, let's say, Mark, 6 months ago, you as an individual bought a foreclosure that MERS did this on. That's a dynamic that nobody is talking about. And our industry...
The Free Press is talking about it.
Okay.
I have it right here.
So what, you purchased the
But it
foreclosure?
was today's Free Press, in all fairness.
It's on my doorstep. I didn't read it this morning. I apologize.
So you purchased the foreclosure from MERS?
Yeah, let's go back 6 months ago.
They don't even have the house, right?
Well, yeah, in other words, MERS did the foreclosure, deeded it over to HUD, and Mark bought a HUD foreclosure.
Okay.
So the world is saying, what's going to happen to those deals that have already closed? And a majority of the underwriters in my world that I've talked to, our industry has something called a mutual indemnification agreement that says that, let's say that Old Republic insured this, a title underwriter that insured this when Mark bought it. If Mark came to me today, I would be able to insure that prior sale because there's already a title policy out there. All right, so I mean, we're not going to go undo the last 4 or 5 years of foreclosure, and I don't think we've heard the end of this, but basically the court has said that the lender is going to have to re-foreclose at not at the former property owner's expense, or they've got to track the property owner down and get a quitclaim deed to clear this up, one or the other.
And here's some...
Or you need a heck of a lawyer.
And,
when purchasing a foreclosure.
Wasn't this a case with Lyle Hall? Wasn't he the attorney?
Lyle Hall, former judge, is the attorney on one of these cases, yes, here in Jackson. Yes.
Who knew?
In Oakland County, they've counted 1,400 foreclosures in 2009 involving MERS, and 555 in 2010.
Yeah.
That's a lot of lawsuits.
Nothing.
Well, the interesting thing is, Greg, when you make a comment, go get an attorney. The bad part is, let's go back to one, the people didn't make their payments, all right? They didn't want to be there, and maybe they've abandoned the property. It is I guess, let's call it a technicality that's going to cost a lot of money, and it's going to slow down the market
Cost a lot of money of whom? The banks?
The banks or somebody in the title industry, depending on how they sort this out. Because in my world, when a bank says they're going to foreclose, they come to a title company and say, hey, do a foreclosure commitment. And you put this piece of paper out saying that if you do X, Y, and Z, you've got valid clear title. So I think the lenders and some of these bigger title companies that have been doing all these foreclosure, I want to see how they're going to sort this out, because 20 years ago, local title companies like myself would be involved in this, but that's all been taken away, thank God.
Well, I also think it's going to affect the cost of the consumer in getting a mortgage, because these banks are going to have to pay for those lawsuits that are going to happen. Now, let's face it, the people who were foreclosed on didn't pay their mortgages.
Correct.
So there is some legitimacy to the foreclosure.
But there's also some legal procedures that need to be followed.
True.
That we have set up as a country and as a state.
True, but the people who didn't pay their mortgages are probably going to reap some benefit out of this.
You know, Greg, this sounds like a broken record, but how many times have I been in here either with Laura and Mark or with Bill saying, if you stay local, sometimes you don't have property or problems like this. So, you know, whether it's a foreclosure issue with shortening the redemption period or this MERS issue, you know, our friends at County National Bank don't have this problem.
Boy, I hope you brought some aspirin this time.
Yeah.
Well, and the local thing is so important. I mean, I talked to a realtor on my way to your radio show today, and you know, she's telling me the lender, who's out of Indiana, I think, or Illinois, he went local to his community where he's moving from because he thought it'd be easier. Well, now they're picking everything apart. They want every single disclosure. Everything's got to be initialed. I mean, that stuff is all well and good, but it's easier to handle when it's a local bank.
Are you taking questions?
Yes.
Good morning.
Good morning. This is Mindy at the Register of Deeds office.
Hi, Mindy.
Hi. Hi, Ron. Hi, everyone.
Hi.
Mindy, I know I owe you a phone call. I'll call you this afternoon. Thank you.
I'd just like to bring it up to what's happening here in Jackson. We have been working with the local TV stations, and our association itself is working with getting information to our prosecutors and to the Attorney General's office regarding the smart MERS issues, because we feel that some of these documents that were signed by Linda Green are fraud, and there's some issues going on. But we did a quick search from 2000 to the present, and we have over 800 MERS as nominee documents in our system right now at the JRC.
And those are current ones that haven't been foreclosed on yet or haven't gone all the way to the table?
I couldn't tell you that. I'm just looking at what has been recorded as a foreclosure. They may have already been taken care of. They may still be out there. I haven't, we haven't gone that deep to figure that out. That's a little deeper than I have staff to be able to do at this point. But we do have documents in Jackson County that are dealing with the MERS issue and with the fraudulent signing of these documents that came out at DOCX, which was a 60-minute, had a big article piece on there regarding this docs, who was a servicing agency, and it just kind of dwindled down from there into the MERS also. And so we are finding a lot of different issues with some fraudulent, we believe, fraudulent documents that have been recorded.
So what's going to happen, Mindy?
Right now, there are a handful of attorney generals throughout the United States that are going to try to go through and do some suing on behalf of the people that, just like you were saying, if you watch this 60 Minutes, and I have a link to that if anybody's interested, they can contact me. It's a link to a 60 Minutes article that showed a lady who was trying to work out saving her home, and because of some of these fraudulent documents and this doc servicing, which is, I don't know if they're the same as MERS, but it's acting as a servicing agent, was nowhere to be found, and nobody would work with them, and they couldn't find out who actually owned their mortgage. Mm-hmm. And that's when Ron was talking about the assignments. These servicing agencies act as a deposit place for them instead of putting a public record where you and I can come in and search those public records to find exactly the full chain. They are holding on to these documents or not recording them, and then something happens and nobody knows who's dealing with what.
And so that will cost the county money from the lack of registration fees. So
that also, but it also affects our the people of Jackson County when they can't, when they need some help and they can't find the documentation, just like what you were talking about. They have to say, prove to me that this and this. Well, if no one recorded it, they don't have any proof, and
right.
It's not their fault.
that's why we also have good title people involved.
That's true.
Whose fault is it? Mindy, thank you. We only have a minute left. Thank you.
Whose fault? It's the industry. I mean, we've created I guess I'm going to say we've created a monster that wasn't well thought out. It's kind of like going to Lansing, isn't it? And now, I'm going to clarify that because Earl Plesky and Mike Shirkey are both doing a good job. So gentlemen, if you're listening, this is not directed towards you.
Oh, they're busy.
But it's frustrating.
Yeah. Go ahead, Mark.
Oh, I didn't.
You're
I was
over
just
there making-
saying 1 minute.
Yeah. 1 minute.
Don't you want us to roll in? Don't you want us to roll into the Mark Daly time frame?
No.
Oh.
I have a headache.
So Ron, I'm sure we're going to have lots more questions, so we may require your presence here
Sure.
again. Okay, thank you.
Yes.
And if anybody has any questions, get a hold of Laura or me, and we'll get a hold of Ron, because he's a busy guy.
At this number.
780-3800 is our office number.
The Academy is trained